Good afternoon and welcome to the Coalition for Healthcare Communications first webinar of 2024, The Future of FTC Regulations and Actions. This is the first of a half a dozen webinars planned by the CHC for the first half of 2024, including topics such as this year's challenges with preserving the tax deductibility for advertising in a presidential election year, the legal perils of AI, and working with the Food and Drug Administration on educating agencies and pharmaceutical manufacturers on the recently released direct-to-consumer pharmaceutical advertising on television, radio, and social media challenges. In the next month, we also plan on issuing through our parent organization, the 4As, and with a couple of webinars entitled Navigating the Health Data Privacy Landscape, which focus on recent state and federal policy changes, as well as a practical guide on what agencies need to know about HIPAA compliance. Also, watch for news of our Rising Leaders Conference, which is scheduled to occur in Washington, D.C. on May 14th, followed by the May 15th with the joint meeting of the 4As and ANA congressional briefings and Hill visits. Before we start, just a couple of housekeeping items. First, this webinar is being recorded and will appear for on-demand viewing in the next few days. Second, please share any questions in the Q&A feature on your bottom tab. Time permitting, we'll be using your questions during the Q&A portion on the latter half of the webinar. And last, please make sure to keep yourself muted throughout the program. My name is Jim Potter. I'm the Executive Director for the CHC. As you are aware, the healthcare marketing profession is undergoing seismic shifts in the last few years on how personal consumer data is utilized, specifically their health data, privacy, and security risks related to the use of online tracking technologies, which may disclose consumers' sensitive personal health data to third parties, as well as new restrictions being proposed on marketing to children. Driving this change are 15 state laws on the books that are anticipated to double in this next year, and a series of federal rulemakings by the Office of Civil Rights, OCR, in the U.S. Department of Health and Human Services, and the focus of our discussion today with the Federal Trade Commission. I'd like to introduce our guest speaker for today's webinar. Elisa Gilson is a senior attorney in the Federal Trade Commission's Division of Privacy and Identity Protection in the Bureau of Consumer Protection, where she co-leads the agency's health privacy portfolio and works on policy matters and investigations related to privacy, data security, and artificial intelligence. She has lectured on privacy and artificial intelligence at the George Washington University Law School and the George Mason University's Scalia Law School. Senior Attorney Gilson will be covering in her presentation several areas, including where the FTC draws its authority, recent regulations and actions concerning health privacy data that are relevant to healthcare marketing community, as well as some practical takeaways for healthcare agencies, publishers, and communication companies. With the available time remaining, we'll be asking your questions posted in the Q&A box. Senior Attorney Gilson, thank you for your time today.
There we go. Thank you for unmuting me. Hi, everyone. It's great to be with you. I appreciate the opportunity. And I just need to start with a couple of housekeeping items, and that is that the views that I express today are my own and are not necessarily those of the commission or of any individual commissioner. And second, I am home with a sick 3-year-old who will hopefully not make an appearance during this, but please forgive me if there are any interruptions. So what I'd like to do is provide you kind of an update on the FTC's health privacy work, and to begin by just providing a little bit of background on the agency. The FTC is an independent law enforcement agency that has a 2-part mandate. You probably have seen a lot in the news about what the FTC is doing on the competition front. So we have our 2-part mandate covers competition and consumer protection issues, and privacy and data security are sort of interesting areas where there's oftentimes an overlap, a nexus between those issues. Privacy and data security are long-time consumer protection priorities, and the Commission takes a three-pronged approach to these issues: enforcement, policy initiatives, and education to both businesses and to consumers. Now, the FTC enforces a number of laws. Chief among them, though, is Section 5 of the FTC Act, which prohibits unfair or deceptive acts or practices. So let's break that down a little bit. Deception. So a representation, this is a material representation or omission that is likely to mislead consumers acting reasonably under the circumstances. What's important here is that it's not just what you say, a representation, but it's also what you may fail to say. So a material omission may be as actionable, as likely to mislead consumers as a material representation. The second part of this is unfairness. A practice is unfair if it causes or is likely to cause substantial injury to consumers that is not outweighed by countervailing benefits to consumers or competition, and is not reasonably avoidable by consumers themselves. Now, that mouthful essentially boils down to a cost-benefit analysis. So there's going to be a lot of focus on what is the harm, because to prove that a practice is unfair, the FTC needs to show that there is a substantial injury. Now, importantly, it is not necessarily that a substantial injury has already taken place, but it can also be that a practice is likely to cause substantial injury. Now, there is sometimes some confusion when it comes to health privacy about what is the FTC's role and what is HHS's OCR's role. And so I wanted to just pause for a moment and kind of clarify how those authorities interact. So importantly, Section 5 authority, so this prohibition on unfair and deceptive practices, extends to both HIPAA and non-HIPAA covered entities. So there are a few carve-outs from the FTC's jurisdictions that are potentially relevant in the healthcare space. So for example, nonprofits, insurers are not within the FTC's purview, but otherwise, most companies are going to be under the FTC's jurisdiction. It's incredibly broad jurisdiction. Because of that, even if you are complying with HIPAA, there is a good chance that you also need to be complying with Section 5. So you could be 100% completely in compliance with HIPAA, but still have Section 5 issues if you are making, if you are engaged in unfair or deceptive practices. I also wanted to flag that HHS and the FTC enforce sister health breach notification rules. So you may be more familiar with the HHS health breach notification rule. The FTC's sister rule applies to entities that are not covered by HIPAA. So how do HHS, OCR, and FTC work together? So we do a lot of coordination. And here I've highlighted a few of our kind of joint actions. We've put out a fair bit of joint guidance. So here's some guidance kind of on our overlapping authority highlighted in the first bullet there. We've also worked together, OCR, ONC, and FDA, all within HHS, worked with the FTC to come up with the mobile health app tool, which helps health app developers understand their compliance obligations. OCR and FTC have done joint enforcement actions like the CVS and Rite Aid matters. The OCR and FTC have done other joint actions, such as in July of last year, sending letters to 130 hospital systems and telehealth providers, reminding them about their compliance obligations related to the use of tracking technologies, which I'll touch on later. But I think the kind of long and short of it is that if you are in the health space, you need to be thinking about both your obligations under HIPAA and what OCR may have to say about that, and thinking about how the FTC is looking at these issues. And the FTC is going to be looking at these issues primarily through the lens of Section 5, but then also, and that brings us to this next slide, through the lens of the health breach notification rule. So this rule requires notification of the breach of unsecured PHR identifiable health information. So that's health information that's in personal health records to individuals, the FTC, and in some cases, the media. As I mentioned, this is a sister rule to the HHS rule, so this rule does not apply to entities covered by HIPAA. It does apply, though, to vendors of personal health records, PHR-related entities, and third-party service providers. Now, in September of 2021, the current commission put out a policy statement in which the commission explained that the rule applies to health apps and similar technologies, and it also clarified what constitutes a breach. That a breach includes not just cybersecurity incidents, but also includes unauthorized disclosures. So if a company is covered by the rule and experiences an unauthorized disclosure of consumers' PHR identifiable health information, then they would have an obligation to provide notice under the rule, and the failure to give notice could lead to an FTC enforcement action. This last year, so this policy statement was in 2021, and that clarified obligations under the existing rule. Then in 2023, the FTC put out a notice of proposed rulemaking related to the health breach notification rule, in which the FTC asked if changes should be made to the rule to clarify its application to health apps, to clarify the definition of the breach, and asking a number of other questions. In response to that notice of proposed rulemaking, the FTC received about 128 public comments, which you can see on the FTC's website. The commission is in the process of reviewing those comments now. Typically in the rulemaking process, a notice of proposed rulemaking is then followed by a final rule. So the best thing here is kind of to stay tuned to see what other developments there will be under the FTC's health breach notification rule. So that, I hope, gives you some groundwork on the authorities that the FTC is working with. Now, the FTC enforces lots of other laws, many of them relevant to privacy, for example, the Children's Online Privacy Protection Act, but I'm not going to delve into those in detail. The two that are most salient in the health space are Section 5 and the Health Breach Notification Rule. So now with that background, I'd like to turn to how the FTC kind of puts those things into action through enforcement actions. And I'd like to walk through briefly 4 recent health-related enforcement actions: GoodRx, BetterHelp, Easy Healthcare, which I'll refer to as Pre-Mom, that's the consumer-facing term of the app, and One Health, and again, the consumer-facing term was Vitagene. So GoodRx, importantly, was the commission's first enforcement action under the health breach notification rule. The commission alleged that this telehealth and discount drug provider shared personal information with third parties for advertising without consent, and contrary to representations that the company had made to consumers. And you can see kind of the bullet points here, the detailed allegations in the complaint. In a similar vein, in the BetterHelp matter, the FTC alleged that this mental health app and telehealth counseling service shared personal information with third parties for advertising, again, without consent and contrary to representations to consumers. And you can see here the very similar allegations that were in the complaint. And then following kind of in a similar vein, you'll see again, very similar allegations here that a fertility app, Pre-Mom, allegedly shared users' personal information with third parties. And kind of the twist here was that this included 2 China-based firms, and there were some harms associated with those disclosures. Pre-Mom, like the GoodRx matter, was brought both under Section 5 and the FTC's health breach notification rule. And then the One Health matter, or the Vitagene matter, in which the FTC alleged that a genetic testing firm left health data unsecured in the cloud, misled consumers about privacy and data security, and made material retroactive privacy policy changes without getting consent. And this last point was the idea. So according to the complaint, the company kind of reserved the right in its privacy policy to make material changes. and said, by agreeing to this privacy policy, you agree to these changes. And the Commission's complaint makes clear that that's not enough. You can't make major changes to the rules of the game simply by reserving rights in a privacy policy. And then I flagged before, so this is relevant to the GoodRx, the Pre-Mom, and the Better Help Matters, that the FTC has worked with OCR, and you're probably all familiar with OCR's Tracking Technologies Bulletin, that FTC and OCR are working together on issues related to online tracking technologies, where these technologies may result in the disclosure of consumers' sensitive personal health data to third parties, and that this can involve significant privacy risk. Now, in just a moment, I'm going to turn to some of the kind of takeaways, some of the lessons learned from these cases. But before doing that, I also wanted to highlight the Commission's security-related work. So all of the cases that I've just mentioned, I've been speaking about them in terms of the privacy aspects, which are incredibly important. I also wanted to flag that the FTC does a lot related to the security of health information. So there are security aspects to the Vitagene and Pre-Mom matters, and you can also see that the CHEG matter, which actually involved an ed tech provider that experienced breaches of health as well as other data, is another security matter. Also along those lines, the SkyMed and Henry Schein matters also involve allegations related to the security of consumers' sensitive health information. So I wanted to get to the meat of this, and those are the takeaways that come from these cases. These takeaways are all summarized in July 2023 health privacy guidance, and I include the link here. You can also just find this on the FTC's website. So the first one is understanding the breadth of health information. So I think kind of a traditional understanding of health information is that we're talking about things like a diagnosis or your symptoms or your medications. But these recent cases make clear that we need to be thinking more expansively about what constitutes health information. So in matters where, let's say, an app event has been given a name from which health information can be kind of determined, that in and of itself is health information. So to make this concrete, so in the Better Help matter, this involved mental health services. So an app event indicating that a consumer is starting treatment, that in and of itself would be health information. So especially when you're looking at things like tracking technologies, thinking about maybe you're creating web events or app events, you need to be thinking carefully about the names that you're giving to these events, and even whether some standard events could be conveying health information because of the nature of the service that's being provided. The second thing is that you need to be thinking about that your obligation to protect health privacy is a given. So when it comes to sensitive health information, that sensitivity is a proxy for harm. So there's a risk of harm when it comes to any personal information, but the more sensitive the information, the greater the risk for harm. And that harm can be from, the disclosure, the genie out of the bottle problem. Once your health information has been exposed, there's no kind of taking it back. And that can result in a lot of harms to consumers. It could be, these are all kind of described in the complaints. But it can be things just the harm and kind of mental distress that comes from the disclosure of health information. And it can be something very concrete. It could affect an individual's ability to get a job or to get insurance. So there can be really concrete harms. Because of that, your obligation to protect this information is a given. So the baseline is set fairly high because this is such sensitive information. The third takeaway is don't use these tracking technologies in a way that contradicts your privacy promises or otherwise harms consumers. So I think oftentimes we see a disconnect between what companies are saying and what they are doing, not from any sort of malfeasance, but oftentimes because there can be a little bit of a disconnect between what compliance folks may understand and may be trying to communicate, and what folks are doing on the ground when they don't realize the implications, the compliance implications of their choices. So enabling that kind of communication within an organization is really important. The next, don't share consumers' health information improperly and don't receive it either. And what this is getting at is, these cases have been focused on the disclosure of health information, and kind of sends the message, companies, be careful about what you're disclosing. But if you are the recipient of data, and you are the recipient of data you are not supposed to be receiving, that can be a problem as well. So again, the FTC is looking at these issues through the lens of Section 5. So think about what are the representations that you're making, and also think about whether your practices are harming consumers. So if you are constantly putting yourself in the position of the consumer, then you will be in good shape to understand what are the potential Section 5 obligations. And I think we've already touched on that last bullet there, so we can move on to the next slide, which addresses kind of the nexus to HIPAA issues. In many of these complaints, the FTC alleged that the companies were making deceptive claims of HIPAA compliance, or that their products were HIPAA secure, or other similar claims. And in many of these complaints, the FTC alleged that these companies were not, in fact, subject to HIPAA, and they were not, in fact, complying with HIPAA. So they were simply making these representations. Oftentimes, they had invented a seal for themselves and put it on their website. So, you may say, well, what's wrong with that? Why not make up a seal and put it on the website if we're trying to comply with HIPAA? Again, we look at these issues from the consumer's perspective. A consumer may take away from a claim of HIPAA compliance that a company is in fact subject to HIPAA and is in fact complying with HIPAA. If those things are not true, probably not a good idea to go there. So it's not that the FTC is kind of looking under the hood at HIPAA compliance. That's the purview of HHS OCR, but the FTC is looking very closely at claims from a consumer's perspective. And then just a quick flag that companies that provide HIPAA seals and certifications can also be liable for deceptive claims. The FTC's brought a case, actually really in the environmental marketing space, against a company that was providing deceptive seals and certifications, and alleged that that company provided the means and instrumentalities to deceive consumers. So be careful about, kind of what you're putting out there and how consumers will perceive it. Oops, excuse me. So then the last set of takeaways, I mentioned in the Vitagene case, the reserving the right to make big changes in your privacy policies. That isn't going to cut it. So where you need to get consent, this needs to be meaningful consent. And that relates to the next point, that euphemisms aren't going to cut it. So be very careful about maybe hiding maybe a practice that you fear consumers may not be a big fan of. Just like, well, we'll give you some euphemisms. Let's gloss over this point. Be very careful about the temptation to gloss over something. Again, you need to be looking at it from the consumer's perspective, to be thinking, will the consumer understand what this is and be able to give meaningful consent to it? That relates to the next point, which is the omission point, that you're equally liable for a representation as for an omission. So be careful not only about what you say, but about what you fail to say. Next point is that the FTC protects biometric data. The FTC put out a biometric policy statement last year that emphasized this point, and since then has brought cases related to genetic privacy, the Vitagene case that I mentioned. There's another genetic case called CRI Genetics, as well as video data, voice data, facial recognition data. These are all very recent cases. Reproductive information should be protected from prying eyes. I think Jim alluded to some of the HHS rulemaking on this point, but the FTC has also brought cases like Premom and Flow Health, which relate to protecting the privacy of fertility information. And that takes us to the last point, that there's a lot at stake. And by that, I mean, take a look at the consequences of running afoul of the FTC. So if you look at the remedies that the FTC has obtained in its enforcement actions, they can be pretty significant. So you see bans on the disclosure of health information for advertising. There have been a number of orders that have required companies to obtain deletion of data that was improperly disclosed to third parties. It's not just the data, but it can be the data product. So that can be the algorithms or things derived from the data, or it can be specimens in the biometric context, the mandated destruction of specimens. So, many companies prize the trove of data that they are collecting and then derive a lot of value from creating data product, from fashioning algorithms from this data. So a mandate to then delete the data or to disgorge or to delete the algorithms or data product can be very significant for companies. More and more, too, the FTC is obtaining monetary relief in its orders. So I mentioned that the FTC has brought its first two enforcement actions under the health breach notification rule. That carries with it civil penalties, and so those can be in the millions of dollars. Also in consumer redress, so BetterHelp is a good example here. This involved requiring the company to pay $7.8 million for consumer redress. The Henry Schein and Vitagene matters also involved orders to pay consumer redress. Other remedies in these orders include notice, requiring the companies to provide notice to consumers about the allegedly illegal practices, requiring the companies to obtain affirmative express consent for disclosures in the future to third parties. The definition of affirmative express consent in these orders is significant because it's defined in a way to preclude the use of dark patterns. So this is really, when we say consent, we mean really, truly meaningful consent. And many of these orders have required companies to implement privacy and/or data security programs that will be monitored, that will be assessed by independent third parties. Orders have also required data minimization, so detailing and limiting data collection or retention. Some have required individual liability, so that really brings it home. It's not simply the company that's on the hook, but it can be a high-placed individual who is who faces responsibility for the privacy and data security practices of a company. And I mentioned earlier the deletion of data product, or the prohibition in the Amazon Alexa matter, the prohibition on generating data product from data you shouldn't have in the first place. So I'd like to switch gears now briefly. So we talked about the FTC's authorities. We talked about the FTC's enforcement actions. We talked a little bit about policy in terms of rulemaking, and I wanted to just touch briefly on education, just to highlight the fact that the FTC has done a lot to try to educate businesses about their compliance obligations. And I provided here some links to some resources that may be helpful that provide these education pieces. On the policy front, I've mentioned several times now the health breach notification rule. The FTC also put out an advance notice of proposed rulemaking related to commercial surveillance and data security. The FTC received substantial public comments. From here, the next steps could be a notice of proposed rulemaking on these topics. It could be a single notice of proposed rulemaking related to everything. It could relate to a subset of issues, or there could be no action from the commission. So we have to kind of stay tuned to see how this will play out. I just wanted to flag that health was a significant component here, that there were many public comments that addressed health issues. So this is an area to pay close attention to. I think I've already touched on the health breach notification rule. So I'll just note that in this commercial surveillance and data security advance notice of proposed rulemaking, some of the health-related issues were, should there be carve-outs for HIPAA-covered data, or should the FTC's rule cover this? Should there be the same protections for all health data? Sort of can be sometimes a similar or a related issue to the first. What are the public health and research implications of restricting health data use? And de-identification. Should there be carve-outs for de-identified data? And if so, what is de-identified data, since folks have sometimes different views of what constitutes adequately de-identified data? So I am aware that I'm getting to the end of my time, and I want to make sure to leave time for the Q&A. So I will pause here and turn it over to Jim and to see if we have received any questions.
Thank you very much, Lisa. Very in-depth, very really appreciate your time and the expanse of the issues that the FTC is considering right now. We will make the educational links that you discussed in the part of the presentation. We'll make that available when we send out a copy of this. We'll have those links attached to the landing page for the recording of this particular webinar. So we don't have any questions yet. If you have any questions, again, please use the Q&A section. So, Elisa, how does the FTC prioritize enforcement actions in the health privacy space? Or what are some of the red flags that they would see that says, oh, okay, this is, you know, we're going to have to focus on this a little bit more?
Yeah, it's a great question. So again, we're looking at everything through the lens. The primary lens is going to be through Section 5 of the FTC Act. So focusing again on deception and unfairness. So a huge red flag is where a company is misrepresenting its practices. And another red flag is where the company is doing something that would be completely at odds with consumers' expectations. So even in the absence of kind of something misleading, misleading representation, where they failed to say something important. Another is consumer harm. So what are the harms to consumers if, for example, consumers' health information is being used in an affected way that can lead to consumer harm? We're going to be looking very closely at those issues.
Thank you. We have one question. Is there a website that we can use to keep up on all the data that's going on the particular changes and updates at FTC?
So the FTC's website is the best place to go. The FTC has a kind of a health tag, so you can use that health tag. But otherwise, our website and kind of the press releases that come out. If you have not yet subscribed to our business blog, I highly recommend subscribing to the business blog. Every time there is a health-related action, or not just health, on any important privacy or security-related action, a business blog post will highlight that so that you'll always get kind of the most up-to-date information there.
Thank you. We'll also include that information on our landing page, the subscription of where you can get to their blogs, as well as the FTC site with the other information. I guess what would be, you gave us a number of great takeaways, but what does the FTC want to send to the industry? What kind of message on health care privacy space? What's kind of where are we kind of going in the future that that the FTC says, okay, no, this is kind of a line you can't cross anymore? And do you think are you getting responses from the community on those messages, or are various companies, agencies, manufacturers still kind of struggling with some of these concepts?
So I think in the past, there may have been a view that when it comes to health privacy, look to OCR, and the FTC is somewhat irrelevant in the space. And so we hope that with these actions, we're sending the message loud and clear that you need to be thinking not only about your obligations under HIPAA, but you also need to be thinking about your obligations under Section 5, and if applicable, that the FTC's health breach notification rule. The technology, health technology, is changing rapidly. So not that many years ago, we didn't all have iPhones and Androids or whatever in our pockets, and we didn't have a zillion apps that were gathering and potentially disclosing health-related information. So how we use technology is dramatically different, and it has been a sea change when it comes to health data. The FTC is really focused on protecting that information. So I think big takeaways are that companies that are interfacing with health data need to be aware of the FTC's relevance here, and to be thinking about putting themselves in the consumer's shoes, to be thinking about how the consumer is understanding these issues, how the consumer could be harmed by data practices, and what are the consumer's expectations.
Thank you. All right, not seeing any further questions, please, last chance to kind of type in something to ask right now. I have one final question. What input from industry is helpful to you at FTC, and what are the best avenues to try to bring that input?
Yeah, we really appreciate the input that enables us to have a more informed and nuanced view of any of these issues. So anytime there is a rulemaking, as for example, right now we have a COPPA, Children's Online Privacy Protection Act rulemaking, anytime there is a rulemaking and an opportunity for public comment, we really urge you to consider submitting public comments. These opportunities too for us to speak to you, but to provide any feedback is always very helpful. We also have public fora in which folks may participate. So for example, we have an upcoming research conference called PrivacyCon that's going to be in the upcoming months and will likely have a health related focus. So submitting to something like PrivacyCon, attending those events, and other kind of public fora are great opportunities for an exchange of ideas.
Terrific. Again, I want to thank you, Elise, for your time. Audience members, thank you for your participation today. And we look toward in the next month bringing you some other topics on this privacy and other issues impacting the healthcare marketing space. Again, Elise, thank you. Really do appreciate your time. Everyone, I hope you have a great day, and we're going to give you a couple minutes back on your hour. So take care. Bye-bye.
Thank you, Jim, and thank you for the opportunity to be here.